An AI company trained its model on your work, made billions, and you got nothing. You've probably heard this story, and your first instinct is probably right. That's not fair. Maybe you should be able to do something about it. But not fair and against the law are two different things. As a lawyer, I can tell you this story hides three very different questions. Did they actually take your work? Was that legal? And can you do anything about it? I've spent almost 20 years inside legal and compliance across multiple jurisdictions. I worked in cross-border deals and disputes, and I'm going to show you exactly where the system leaves you powerless and where it doesn't. By the end of this video, you'll have all three answers. At least one of them will surprise you. Grab a coffee. Here is what most people think, and there are two camps. Camp 1, AI companies scrap the whole internet. That's obviously theft, and the courts are about to fix it. Camp 2, nothing was taken at all. The models just learn patterns like a person reading in a library. Both camps are wrong, and what's actually happening is more interesting than either. So let's take the three questions in order. Question 1. Did AI companies actually take your work? If your work has ever been on the open internet, the answer is almost certainly yes. Start with what a court actually found. In the Anthropic case, the company downloaded over 7 million books from pirate libraries to use as training material. Not licensed, not bought, downloaded from the same shadow libraries a student would get in trouble for using. That is, by any measure, a lot of reading. The New York Times went further. In a lawsuit against OpenAI, it showed that ChatGPT reproducing Times article near word for word, not inspired by, near verbatim. And here is the technical part everybody skips. Before a model learns anything, the works are downloaded, stored, and processed. Copies are made at the very start. Under copyright law, making copies is the author's exclusive right. So the copying itself isn't really in dispute. What's disputed is what the copying means legally. And we'll get back there in a minute. But before we go to the law, here is the part that many people miss completely. You might be feeding the machine right now. Several of the biggest AI tools train on your conversations by default. Anthropic's Claude changed its policy in 2025. Your chats can train the model unless you opt out, with retention up to 5 years. ChatGPT's free tier, same principle. The switch is buried in your data settings. The consent was in the terms. Sounds familiar? You clicked I agree. That was the video 1 on this channel, which makes you, again, one of the most generous investors in Silicon Valley. Question 2. Was any of that legal? And this is where it gets genuinely interesting, because the courts around the world are answering this right now, in real time, and they disagree. First, AI companies' defense, and stated fairly, it's not absurd. They argue that training is fair use. The model doesn't store your article, it learns statistical patterns from it. Their analogy, a person reading a library and learning to write. And one federal judge partly agreed. In the Anthropic case, training on lawfully bought books was ruled out, quote, spectacularly transformative, fair use. And transformative means learning from the work to create something new rather than simply copying it. Copyright protects not ideas, but the form in which they are expressed. So the 7 million pirate books, that's a different story. That's what the $1.5 billion settlement was for, about $3,100 per book. But 4 months before that ruling, a different federal judge went the opposite way in the first decision on this question anywhere in the United States. Thomson Reuters versus Ross Intelligence. A legal AI trained on Westlaw's copyrighted headnotes. The court said not transformative, meaning reusing the original work without a fundamentally different purpose, not a fair use, infringement. Why did two judges land in opposite places? One word keeps deciding these cases nowadays: Competition. The court found Ross AI competed directly with the very product it was trained on. That's the pattern emerging across the case law. When the output competes with the market for your own work, courts lean your way. When it doesn't, fair use gets traction. That Ross case was argued on appeal before the Third Circuit on June 11th. The first appellate ruling in history on AI and fair use could land any week now. And the New York Times case still headed to trial. This month, the Times asked the court to sanction OpenAI for allegedly hiding evidence about its training data. And here's how strange the global picture is right now. Last November, 2 European courts answered the same question in the same month in opposite direction. London, the UK High Court ruled that a trained model does not store copies of the images it learned from, and Getty largely lost against Stability AI. Munich, the German court ruled the opposite, that memorized song lyrics inside a model are infringement copies. OpenAI lost and is appealing. Same question, same month, opposite answers. And zoom out further. Japan, training on copyright works is explicitly permitted by statute, with limits if the output reproduces the original. China, courts have allowed training as fair use, but held an AI platform liable when its output copied a famous character. India, the Delhi High Court has heard a news agency case against OpenAI, and the EU, new transparency rules force AI companies to publish what they trained on. So the law is moving in 6 jurisdictions at once, potentially somewhat different directions, which brings us to the question 3, the one that decides whether any of this helps you. Can you do anything about it? And here is the math nobody puts in the headline. Your claim as entrepreneur or professional whose work was in training set perhaps $3,000, and pursuing on your own, that's not a lawsuit, that's financial self-harm. But sometimes you're not always on your own, and this is where it gets counterintuitive. It actually depends on one thing, whether you ever clicked I agree blindly. So track 1, your work was scrapped from the open web, a published book, your blog, your photos on your own website. You never signed anything with AI company. And if you are in the United States, this is where a classic legal tool exists for the spread out harm. It's called the class action. That's what the Anthropic authors did. 500,000 works pulled into one case, $3,100 per book on average. Slow, yes. A settlement, so no precedent, also yes, but real money reaching authors. Track 2, your work lives on a platform, you uploaded it there, and you clicked I agree on the way in. Inside those terms, a broad license, grants, and on many platforms, a waiver of your right to join class action. The tool that works for track 1 is signed away in track 2. Again, video 1 on this channel, the system is layered, which produces the strangest sentence in this whole story. The professionals and creators who never agreed to anything have more rights left than the ones who clicked I agree. And suing across borders, remember the jurisdiction map from video 2 on this channel? Say you win in London and now enforce that against a company in California. More years and more money. I spent years dealing with some cross-border disputes. Winning is one thing and enforcing abroad is another. And even a clean win raises a messy question. Can a trained model really be switched off for one artist's work in one country? At best, that's technically very hard, which is why these cases end in settlements, not in orders that change the model. Settlements are private, no precedent is set, no rule changes. The next company trains, gets sued, settles, and the cycle repeats. And with the amounts now flowing into AI, hundreds of billions a year in build out, even $1.5 billion settlement reads less like a punishment and more like a licensing fee, paid late. So train first, settle later. The litigation budget is a line item. So step back, past the cases, past the settlement, because the real story here isn't about copyright at all. It's about what happens to the value of intellectual work when enforcing your rights costs more than the rights are worth. AI didn't break that balance. The break was always there. AI is just testing at a scale the legal system never anticipated. So millions of creators, each claim tiny, the aggregate enormous. It's like pollution. No single factory emission kills you, but the cumulative effect is catastrophic. The law's answer to that was collective action. And as you saw, it kind of works when the agreements or terms haven't signed it away. The deeper problem is a gap in legal systems themselves. And if they don't adapt, copyright protection may survive in the books, but fades away in practice, because enforcement against the new AI platform every month becomes unimaginable. And that raises a bigger question, one that I'm deliberately not going to answer for you. Is AI becoming air? We treat air as belonging to everyone. The internet has drifted the same way. Try even reading your own laws today without it. Now AI, trained on the collective work of humankind, is becoming a layer where the work itself gets done, and access to it is controllable. This June, one letter from US Commerce Department switched off the world's two most advanced AI models for every foreign national on the planet overnight. Meanwhile, one AI company has offered the US government a 5% stake. A Senate bill proposes 50. So, is AI just a commercial product built fairly in legal vacuum by companies taking a valid business risk? Or has it stepped into what could become a new pillar of human rights? Something like air that should belong to all? I genuinely want to know where you land on this, and that's what the comments are for. Now, what can you actually do this week? The big questions are still being decided, so nobody can hand you a full shield yet. But 3 moves cost you almost nothing and put you ahead of most professionals when the rules do land. 1. Open every AI tool you actually use and find the training setting. Opt out where you can, 2 minutes per tool. 2. If you publish creative work, know your platform's type. Some exclude your work from AI databases by default, some make you opt out yourself, and some don't give you that option at all. 30 seconds to check which one you're on. And 3, if you license out your work professionally, consider adding an anti-AI training clause to your contracts. Some already have one, and yours should. If you don't have one, I've put a sample clause in the description. Take it as a basis and adapt it to your needs, jurisdiction, with your AI or lawyer. So 3 questions. Did they use your work? Almost certainly. Was that legal? That's being decided right now, from California to London to Munich to Delhi to Tokyo, by the parties with the budgets you don't have. And can you do anything? You now know all the 3 answers, which track you're on, and where your leverage actually is. Next question on this channel: if AI can already do legal research, draft contracts, analyze cases, will it replace your lawyer? The data says the opposite of what you'd likely expect. And that's next. Subscribe, we're following the incentives one system at a time. And remember, you don't need to be a lawyer to protect what's legally yours.